person is guilty of a felony of the 3rd degree if he or she intercepts, discloses, or uses evidence of a wire, electronic, or oral communication in violation of the Act. It's important to note that there's 3 different things that can violate the Act: the original interception of the communication, which we will define, the disclosure of that communication that was intercepted, and then the use of that, say, in some sort of litigation. There are some definitions provided to us under the Act. The most important thing for us to recognize is there's basically 2 different types of communication. There's an oral communication, which is your in-person communication. So if I was talking to Paul in the office face-to-face, not relying on any technology, that would be an oral communication. The other one is either electronic or wire, and that's when I'm relying on technology, like a phone, a computer, some sort of technology that's connecting us and allowing us to communicate. It's also worth noting that the only type of communication that requires a reasonable expectation of privacy in order to be protected by the Act is the oral communication. So if I'm speaking to Paul in public, say outside work and there's a bunch of people around, and I do not have a reasonable expectation of privacy, this does not count as an oral communication, and the Wiretap Act does not protect it. The Act defines intercept as an oral or other acquisition of the contents of any wire, electronic, or oral communication through the use of any electronic, mechanical, or other device. So anytime I pull out my cell phone to record something, I record something on Zoom, anything like that, that would qualify as an interception. Because the Act is so broad, there are several exceptions. It lists 18 exceptions, one of which has now been deleted by amendment. Most of the exceptions apply to individuals working as or with law enforcement. So people that are confidential informants, they're wearing a wire, most of the exceptions apply to them, or service providers such as electronic communications or public utilities. However, there are 2 exceptions that may prove useful to victims of crime who are not working with law enforcement, and those are what I will discuss throughout the remainder of this presentation. They're the mutual consent exception and the crimes of violence exception. The mutual consent exception says that it's not unlawful and no prior court approval shall be required if a person intercepts a wire, electronic, or oral communication where all parties to the communication have given prior consent to such interception. It's important to note the word prior here. I have heard a common misconception that if your client is recording some incident and during the recording they say, "I'm recording you," that this would be sufficient because the other person is put on notice. That is not accurate according to the Wiretap Act. According to the statute, there must be prior consent. Based on case law, this consent may be characterized as express or implied consent. And just a further note on the prior, it will depend your jurisdiction. It will depend on what the prosecutor views as their interpretation of the Act and what the judge views as their interpretation of the Act and what prior means. However, the Superior Court has made it clear in their decisions that prior very likely means prior. For express consent, this is where things like voicemails, online chats, emails, text messages come in. Pennsylvania courts have held that the mutual consent exception applies and fits situations such as these. And as Paul was saying earlier, it fits these because by their conduct, the sender expressly consents to the conduct, by their conduct to the recording of the message. So when I send a voicemail, I know that the recording of the message is going to happen on that machine. And so the courts have held, because you're sending it to a machine where you know that there will be a record of it, you should also know that someone could use that in the future. They could save it, they could forward it. There was a case called Torres where a party, the court said, had obviously consented to a third party being present and using and disclosing the communication because he demanded that he be placed on speakerphone. So it will depend on your court. The other type is implied consent. This one has been harder for Pennsylvania courts to nail down whether or not implied consent is sufficient, like express consent is. It has been applied where individuals were actually aware that a conversation was being or could be recorded. In a case called Bird, the defendant was in prison. He was in prison and was making a call from the phone in the visiting room. And during that call, the other party, I think that Bird was threatening the other party and they recorded the call, or they got the record from the prison. And he objected to the evidence, saying that it was a violation of the Wiretap Act. The court held that a hyper-technical analysis of consent was not required and the exception should automatically be applied. And that was just based on the fact that when you make a call from prison, they have a little recording that says, this will be recorded, it could be used. And so he was aware that he could be recorded and he would be. And also they looked at the fact that on the phone call, Bird said, I'm going to say it on the phone, I don't care. So they said he was obviously aware that he could be recorded at any time. It's less clear whether this would be the same result if it was on a call, such as you call customer support and they have that recording that says the call could be monitored for quality and training purposes. I did not see any case law on whether or not that would be sufficient. I find it less likely that it would, because we know that people that are in prison have less of a privacy interest than people outside incarceration. In another case dealing with implied consent, it was NF versus BF. And I believe that the parties in this case were speaking in a public park face to face. So we know there that we are dealing with the possibility of an oral communication. And whether to apply this exception to a video, the court looked at testimony suggesting that the intercepted party consented to the videotaping because she noticed she was being recorded, continued to escalate the incident, and there was no evidence that she asked for the recording to stop. Unfortunately, for our purposes, the court didn't end up deciding whether or not that would be sufficient for implied consent because, as I said before, an oral communication requires a reasonable expectation of privacy. The court said because she was in a public place, she did not have a reasonable expectation of privacy, so it was not an oral communication, and the Wiretap Act did not protect her communication. So they didn't end up having to decide that issue. The Pennsylvania Supreme Court has also been faced with this question. In Arlington, the intercepted party was charged with first-degree murder and unlawful possession of a firearm and argued that evidence of a phone recording should be excluded based on the act. The Commonwealth argued that the intercepted party expressly consented to the recording of his phone call because he repeatedly stated during the conversation that he did not care if the other party was recording the call. So like I said before, this addresses the assumption that just because you say, I'm recording the call, does that equal prior consent? The court did not resolve the case on that point. Instead, they ended up deciding the issue by stating that his phone call was cumulative of other properly introduced evidence with substantially similar content, so the recording constituted at most harmless error. So once again, we see that there is this question of what is implied consent, what is prior consent, and as of yet, the court has not specifically stated that I could find.
Lisa, let me ask you a question, if that's okay.
Mm-hmm.
So you call me, I 5 minutes into the conversation, record it and tell you I'm recording, and you say, okay. Once you gave me consent, can that part of the recording come in, or is the entire thing struck out under wiretap?
This is one of those things that will depend on the judge and also on the prosecutor as to whether or not he finds it proper. Arguably, after you give me the consent, then the portion after that, I would argue, is fine under the mutual consent exception because the prior consent would be met based on the party's agreement to the recording. The portion before that would be less likely to get in because of that prior consent requirement and the fact that you only did it partially through the telephone call.
Okay.
So in the Arlington case where they were discussing the issue of prior consent, because they didn't give an official ruling on what constituted prior consent, what constituted implied consent, then Chief Justice Castillo decided to provide a concurring opinion saying that in his view, intercepted party manifested his consent to the recording of the telephone call to the victim during the course of the call. He pointed out that the statute does require prior consent, but does not specify that the consent must be explicit in response to explicit disclosure that the interception is in progress. So in his opinion, it would have been sufficient to plead the exception and especially relevant because the recording contained highly probative, relevant evidence. So it will depend on the judge and their interpretation of the act. The other exception that's helpful for useful for crimes of violence is the crimes of violence exception, and it says that it shall not be unlawful and no prior court approval shall be required under this chapter for any victim, witness, or private detective to intercept the contents of the wire, electronic, or oral communication if that person is under a reasonable suspicion that the intercepted party is committing, about to commit, or has committed a crime of violence. And there is reason to believe that the evidence of the crime of violence may be obtained from the interception. It's noteworthy here that this applies for any victim, witness, or private detective. So if you're representing a victim of violence and it was their friend who was present and recorded it, this exception could still apply. It's also noteworthy that this only applies for specific crimes of violence that are outlined by the statute. I have heard a common misconception that if any crime is occurring, it's okay to record someone, and that's not accurate according to the Pennsylvania Wiretap Act. It is only outlined crimes, which I will go over. It does not provide its own definition of reasonable suspicion, so it likely mirrors that used in criminal procedure context, which is more than a hunch based on specific facts taken with rational reference to those facts. As I was stating, these are the specific crimes that would qualify for this exception. They are relatively serious crimes. They are all felonies of the first or second degree. It's things like murder, voluntary manslaughter, some sexual assault, and the Act lists specific subsections. So if they're not within those subsections, you can't plead the crime of violence exception successfully, most likely. Before this exception, there was a case called Deck in 2008, and there was a minor victim. She was trying to convince her mom that the intercepted party was sexually assaulting her, so she recorded her phone conversation with him. The crimes of violence exception did not yet exist, and the Commonwealth in this case, during the prosecution of her abuser, stated that the act should be extended to cover victims of violence, so that way they can record evidence of their crimes. The court said that's up to the legislature. They refused to create this exception, and then the evidence ended up being thrown out. The Pennsylvania legislature then amended the act 4 years later by adding the first version of the crimes of violence exception, which ended up superseding the decision in Deck. When it comes to pleading the exception, a good case to look at is Poteet, which is a 2018 PA Superior Court case. In this, the intercepted party filed a private criminal complaint against her daughter, her son-in-law, and the couple's attorney for violations of the act. What had happened is that it was a mother and her husband on the phone with daughter, and daughter secretly recorded her phone conversation. In the conversation, they were talking about some sexual abuse of daughter that occurred previously. And then daughter ended up hiring an attorney and brought a lawsuit against her mother and her mother's husband for that sexual abuse. Mother, intercepted party, ended up filing a private criminal complaint against her daughter, her son-in-law, and the couple's attorney for violations of the act. The district attorney refused to prosecute the parties and stated that it was not in the best interest of justice to prosecute individuals for crimes which are related to the crime of which they are a victim, unless the alleged crime is determined to be more serious in nature or consequence than the crime of which they are a victim. So basically he was saying because she was the victim of a sexual assault, he did not think that it was worth it to prosecute her for recording evidence of that crime, because that crime in his eyes was more serious than a violation of the Wiretap Act. And then in regard to the other two criminal complaints, which was the son-in-law and the couple's attorney, the district attorney said that there was a lack of sufficient facts to establish probable cause against them.
Alisa, we did get a question that I just want to interrupt with for a moment. This person writes, I did not see an exception for a crime regarding physical violence. Does that mean crimes like aggravated assault or simple assault do not qualify? For example, if they have a client videotaping a defendant striking her, would that be inadmissible pursuant to the PA Wiretapping Act?
So if you look on that third bullet point there, there is one for aggravated indecent assault, and then the second one, there's aggravated assault. It's just certain subsections. So your difficulty there would be pleading that your client was not experiencing simple assault, she was experiencing aggravated assault. So that's going to come down to the judge's interpretation of what your client was, how your client was perceiving it, why she expected this assault to be aggravated and not just simple assault. Because if it was simple assault and the judge believed she was only going to experience a simple assault, then that would not qualify and you would not be able to get it in under this exception.
Thank you. And just before we continue, I'm going to launch our second poll. Like the first poll, you need to answer it for the CLE credit and it will stay up for 2 minutes. You can go ahead, Alisa.
So in the Poteet case, the trial court affirmed the district attorney's denial of the complaints. So the intercepted party appealed the trial court's decision solely pertaining to the couple's attorney. So she didn't bother with the complaint against her daughter or her son-in-law. Instead, she only pursued these actions against the couple's attorney, which is important for people representing victims of violence because it points out the fact that both criminal and civil litigation can be pursued against us if we use this evidence in court in violation of the Wiretap Act. In their analysis, the Superior Court focused on this exception. They reasoned that the court finds no probable cause exists to believe that daughter did not have reasonable suspicion that both intercepted party and her husband had committed crimes of violence against her or conspired to do so, and the evidence of such crimes would likely be obtained from the recording of these conversations. This is important because it reminds us that there's a couple different elements here. The victim must have reasonable suspicion that a crime of violence is going on, and they also have to have reasonable suspicion that evidence of this crime will be obtained from their recording. Just because a crime has occurred or is about to occur does not necessarily mean this is okay. You must also prove that you will get evidence of that crime by reporting the act. And so the court affirmed the decision and said neither any of the co-conspirators, which were the couple's attorney and the son-in-law, would be in trouble because that exception did apply for daughter, and therefore the interception was not illegal. And continuing on with the reasonable suspicion analysis, it's not always the easiest exception to plead. It's not always that easy of a burden to overcome. In a recent case called Mason, and this actually, I believe, came out of Dauphin County, and it was in 2019 that it was in front of the Superior Court, they spoke about this lacking reasonable suspicion. In this case, father hired a nanny to watch his kids in his home. His son soon told him that nanny had been hitting the kids and he saw injuries on the children. There was a split lip on his young daughter, and then there was some markings on his son as well. So father confronted nanny and she denied it. He waited 2 months, and then he installed a hidden camera in the kid's room, got evidence of the violence. There was an incident where she did strike the children on the camera, and he gave it to the police. The police ended up pressing charges against the nanny, and she argued that the evidence should be excluded based on the Wiretap Act. The trial court agreed with the nanny, and so then on appeal, the Commonwealth argued that it had satisfied the crimes of violence exception. They argued that that the father was under reasonable suspicion that an aggravated assault had occurred, and therefore the exception should apply. They also made a second argument that even if the exception did not apply, the video and nonverbal audio portions were not protected by the act. The court ended up holding that while the injuries could have given father a reason to believe that at one point nanny had assaulted his child, there was no clear evidence as to when the injuries occurred or whether they were ongoing. The court stated that these limited facts are insufficient to show that father had a reasonable basis to think that the recording would produce evidence of the type of aggravated assault necessary to satisfy the wiretap's crime exception. This is important because it once again points out the difference between you believing a simple assault is going to occur or an aggravated assault is going to occur. They said based on the facts, and I think it's really significant that the father waited 2 months to install the camera. I believe that weighed in the court's decision of thinking he didn't really think an aggravated assault was going to happen. Otherwise, maybe he would have installed the camera sooner. They didn't specifically say. And then regarding the Commonwealth's arguments concerning the admissibility of the other portions of the recording, the video and nonverbal audio portions, the court held that if an oral communication is rendered inadmissible, then so is the evidence derived therefrom and any information concerning its substance, purport, or meaning. In Pennsylvania, courts have held that video, unlike audio recordings, are not prohibited under the act, so long as the video does not capture the content of any oral communication. So if you can clearly tell, say, by the lips of the person that you can read what they're saying, then that would be excluded. But if the video is not shining light on the audio portions, it should be allowed under the act. However, the court in Mason held that the nonverbal audio portions of the recording, such as the sounds of nanny hitting and shoving a child, were protected by the act and should have been excluded. They argued that they shined light on the substance, purport, or meaning of her actual audio. So because of that, the sounds of the abuse were excluded. And this decision was appealed to the Pennsylvania Supreme Court. And in September 2019, the court granted a petition for allowance of appeal in regard to 2 issues: whether a babysitter has a reasonable expectation of privacy in the bedroom of the child she's caring for, and whether the sounds resulting from a child being forcibly thrown into a crib and beaten constitute oral communications or evidence derived therefrom. This could potentially be very powerful precedent if they hold in favor of Mason and they say, yes, the sounds of the abuse, the sound of the child being thrown and beaten are protected communication under the Wiretap Act. This can create even more difficulties for victims of violence trying to use evidence in court, because even those sounds can be helpful when proving your case that abuse has occurred. And without them, you're left with possibly only the video and possibly even less than that. When it comes to results of the wiretap violations, there's a few things that could happen. It impacts the admissibility of evidence. The intercepted party may move to suppress the contents of the intercepted communication without having to show that he was prejudiced by the violation. While some courts construe the act broadly and forbid any testimony that tends to disclose the contents of a wiretap violation, the court in Torres held that the interceptor could testify to the recording's contents despite the violation of the act. The intercepted party argued that the act requires both the suppression of the recording and preclusion of any disclosure of the content of such recording. The Superior Court disagreed, stating that the statements were admissible as admissions against penal interest. Courts have varied in application when deciding to exclude only audio or both audio and video. However, it's important to note the Superior Court has held that it was erroneous for trial courts to needlessly exclude video recordings. So if the video is really not shining any light on the audio portion and the trial court still decides to exclude it, that should be appealable to the Superior Court. And another thing that could happen is the court could rule on harmless error. Like they did in Arlington, the court held that failure to exclude evidence of wiretap violations was harmless because the recorded communications were cumulative of other properly introduced evidence. Another argument that was made in DEC was that the Commonwealth attempted to argue the recording was admissible under the inevitable discovery doctrine, despite its interception and contravention of the act. However, the Commonwealth failed to properly raise the issue, so the court did not decide it on its merits, and we don't know whether or not that would have been a successful argument. Another potential outcome could be civil liability. The act provides a civil cause of action for violations of the act, where the person can receive actual damages, punitive damages, attorney's fees, and costs. However, it's worth noting that it is a defense if the actor acted in good faith reliance on a court order or the statute. So say, for example, the trial court lets the evidence in, says it's not violating the act, and then the Superior Court ends up saying, no, it was a violation of the act and it should have been excluded. The intercepted party does not then have a cause of action against your client because they were relying on the order of the court saying that the evidence was okay to come in, so the disclosure was not in violation of the act, or at least there was a defense to it.
Alisa, may I interrupt with another question? We had one that says, so is the burden on the victim to determine whether to record a physical assault, the attorney reviewing the case, or do you submit it and let the judge decide? It goes on to say, this exception seems subjective as to what constitutes an aggravated assault versus a simple assault, since the major difference is someone caused or intended to cause a serious bodily injury versus bodily injury.
Yes, I agree. I think the statute is very subjective. I do not think that it is helpful for victims of violence. I think that it should be very expanded. It is very subjective. And how does your client know whether they're going to be a victim of a simple assault versus an aggravated assault? Do they know the difference? Do they know in that moment whether or not it's okay for them to pull out their phone and record? It's very subjective. And that's why some of the tips I'm going to discuss really quickly are very important because it will depend on the court that you're in front of. And when it comes to the burden, I would be careful even disclosing it to the judge in the first place, because anytime you're disclosing this evidence, it could be a violation of the act. Whether or not you think you're justified, that's arguable, but I would just be careful with the evidence in the first place. For practice tips, you should stay up to date with case law and statutory changes to the act. Like anything else, it's changing rapidly. If you notice throughout the presentation, lots of these cases were from 2017, 2018, 2019. So this is a very timely issue, especially with technology getting more and more advanced. You should also get to know the prosecutors and judges in your jurisdiction and learn their preferences and practices for cases involving potential wiretap violations. You should learn the prosecutor's preferences, whether they bring charges against just the clients that are recording in the first place, or if they also pursue charges against their attorneys. And learn whether judges tend to exclude only audio content or whether they also exclude video and testimony. Be clear with your client about risks. There is a lot on the line for our clients. They can be pressed charges against for criminal action or for civil liability. So we should be clear that using this evidence could be more harmful than helpful in some circumstances. And be an advocate and lobby for change. Like I said before, this exception was created in 2012 and no crimes have been added to the list since that time. If you're familiar with the strangulation statute, you'd know that it was created in 2016 and it was changed so that strangulation against a family or household member, caretaker, sexual violence, or in conjunction with sexual violence is now a second-degree felony. That is relevant for these purposes because if you remember from the crimes of violence list, they were all first or second degree felonies. It doesn't contain misdemeanors, things like that. So the fact that strangulation was later in these cases created as a second-degree felony is relevant because it should be included in that act. It's just that the act ended up coming first. It was in 2012, strangulation was in 2016. So I think that's a good window to argue to the legislature that this should be updated. Victims of violence crime face a wide range of struggles in their everyday lives. By taking the steps discussed, the advocates can help prevent the re-victimization of these survivors and strengthen the prosecution of their abusers. I'll take any more questions if there are.
Yeah, we had three new questions. How does devices like video or the Ring doorbell, how does the video evidence work from that?
So it's the same analysis because that would be a device under the act. And there's actually some questions about this because there were some police departments that were teaming up with Ring doorbells and providing them to victims of violence. And so I don't personally have a Ring doorbell, but I believe it does record audio and video. So I would be careful with any audio portions of that because that could be in violation of the act. Even if they notice that the camera is there, I would be very careful with that and at the very least exclude the audio portion because that's the most questionable part under the act.
And does a sign have to be put up like this property is protected by surveillance?
I assume that would help your analysis because you could then argue, you know, that their conduct is that expressly consenting to the recording. However, it's one of those iffy areas. It seems like the Wiretap Act really values privacy over safety and over law enforcement, which is one of the issues that I have with it because it's not helping victims to have privacy is important, but so is the safety of our clients. So is the prosecution of their abusers and the purposes of law enforcement. So yes, I think that the signs could be helpful. I do not think that there's a clear cut, yes, that would be okay.
Just one last question. I am conscious of us being a few minutes over time, but if a defendant leaves a threat on the phone, in a phone message that's on the phone of the PFA's petitioner's new boyfriend, can the petitioner enter it? So if it's a voicemail, yes, I don't see why not, because that's when we go back to the express conduct, the express consent based on conduct. Anytime you're leaving a phone message, if it's recorded, if it's a live phone call, no, that is more applicable for the other exceptions we talked about. But if it's something that's already recorded, I would say it was expressly consented that could be used in some sort of action, and therefore the mutual consent exception would apply and that would be okay. Thanks, Alisa. We did have one more. This is the last I'm going to take because I want to be conscientious, but I think it's important. It says, if in public, do they have a reasonable expectation of privacy, say on your front porch? I think that will come down to the facts and the court will determine the circumstances because in the NF versus BF case, they didn't just say simply because they're in public, no reasonable expectation of privacy. They examined the facts that she knew that she was being recorded. She knew that there were other people around. So I would say it's going to come down to the trier of fact looking at, it will be the judge deciding admissibility and things like that. So I would just be very careful with the facts, be able to plead the facts well, and be confident that there was no reasonable expectation of privacy there. I wouldn't just say because they're outside, there is no reasonable expectation of privacy. Also, if they're on a porch and it's their own home, that's its own factor because you do have a reasonable expectation of privacy in your home. So I would look into case law on what constitutes in your home. Thank you, Alisa. Thank you to Paul and Alisa for this really educational presentation. These slides are available in Sketch, as Paul noted. Is there anything that either of you would like to say before we end this session? One last thing from me. There is a quick graph there. I tried to create it to sum up all the information for practice purposes. It discusses both exceptions and when it would apply. This will be available on the slides and also in my paper if you feel the need to look at that.
And the only thing I would just say, just in signing off, and you know, thank you, Lisa, so much for today, or letting me present it with you. I'll put it. You know, for anybody that's doing trial work, it's great to be on top. You know, we do CLEs, we do these plan events. Make sure you're doing ones on evidence. You know, good refresher, especially those of us that are in, you know, in trials or in hearings weekly or daily, are really beneficial. And it never hurts for us to continue to hone our skills. So, you know, we hope this, at least the first half, I hope it gives you some things that you can use in court. But again, you're sometimes going to have a judge who was a prosecutor for 20 years and they think they know better than you, which I'm dealing with right now in Cumberland County. But, it happens. So, but keep it up. We do have our information on the final slide if you need anything. But we appreciate everyone's time. And again, thank you, Alisa, and thanks everyone for being here this morning.
And thanks, Plan, for having us.
Thank you.
Yes, thank you.
Have a good day, everyone.